profesor Greg Lastowka. Greg Lastowka es profesor de Derecho en la Universidad Rutgers de los Estados Unidos. Su actividad de investigación se ha centrado principalmente en analizar las relaciones entre la propiedad intelectual y las nuevas tecnologías y ha publicado numerosas publicaciones, de las que podríamos destacar principalmente su libro Virtual Justice, publicado en Yale University Press el año 2010, que explora las complejas cuestiones de cómo el derecho se aplica a las nuevas formas de comunidades en línea. Asimismo, ha estado trabajando sobre otras cuestiones vinculadas a la regulación de Internet, a la propiedad intelectual o a las marcas en línea. Y los resultados de su actividad de investigación se han publicado en numerosas publicaciones, revistas, muchas de ellas de gran impacto, como son la California Law Review, the Indiana Law Review, and the William Mary Law Review o the Boston University Law Review. Bien, sin más, pues cedo la palabra al profesor Lastowka. Dear professor, thank you for accepting our invitation, and the floor is yours.
I would first like to, thank you. Gracias. I'd first like to start with just a little bit of description of my book, which was just mentioned. My research focuses on three primary areas: trademark law, copyright law, and virtual worlds. And the book is primarily a discussion of virtual worlds, which are a technology which is avatar-based, social, online, creating persistent spatial simulations. Actually, these forums have been around for a long time. As I explained in the book, they've been around for about 30 years, if not longer. So the book is actually sort of an introduction to virtual worlds generally and to legal questions that arise in virtual worlds. And you may be surprised to know that there's been roughly 200 law review articles, if not more, about law specific to virtual worlds in the past few years. So my book starts with a discussion of castles, and there's a castle theme that carries throughout the book. I use the castle as a metaphor for the virtual world platform. And what I found interesting about castles historically is that castles formed a new site of culture for civilization and a new site of law, that castles had courts. And that castles were a new form of technology that was used to exert power over a community. So in the book, I talk about how castles and how virtual worlds primarily have altered certain fundamental building blocks of the legal system. Jurisdiction, property, contract have all been altered by virtual worlds. And I think that could be said of the Internet generally, but the book focuses specifically on virtual worlds. One issue I dealt with throughout the book kind of consistently was the problem of virtual property, rights and intangible items that people had in virtual worlds that formed virtual economies. You may not know this, but there's around $6 billion per year being traded online in virtual economies. Of course, intellectual property, copyright, which is my main theme for today, is part of virtual worlds as well. This is a walled garden in the virtual world of Second Life, and obviously this and the castle I showed in the last slide would both count as copyright protected works. This is a virtual 3D sculpture. It has animations, it has sounds, it has computer scripting, and all of this falls within the ambit of copyright law. But I should stress that when I first started writing about virtual worlds and researching virtual worlds, I did not really want to talk about copyright because there was a sense that when I talked about virtual worlds, that copyright solved the problems of virtual worlds. The thinking was sort of like this. A virtual world is a company's private creation. A company has basically absolute control over a film or book it produces as a form of entertainment. So just as an author has complete control over the work, so a virtual world provider should have complete control over what happens in a virtual world. And copyright, therefore, solves everything that might happen in a virtual world. And to that, of course, I replied, no, copyright is not a police state. Copyright does not create a system of governance, right? It's not a sound basis for the foundations of law, and so, therefore, I talk about contract. I talk about jurisdiction. I talk about criminal issues that really don't interface with copyright. But I may have protested too much in the sense that copyright law, of course, is extremely important to virtual worlds. And the thing that I found most interesting about copyright in virtual worlds, and I did finally get to copyright in Chapter 9 of my book, is the way in which users actually contribute much of the copyrightable expression to a virtual world platform, and the way in which the user, him or herself, when entering into a virtual world, in a way is constituted by copyright. So this is just a login, the first entrance screen to a virtual world platform. This isn't Second Life or any popular platform, but this is just your basic avatar customization screen. And if you look at it, right, it's a copyright moment in that there are copyrightable bits of expression here that the user is assembling to create their identity that will cloak them and present themselves to others within the context of a virtual world. So even the very first step of embodiment in a virtual world, fashioning an avatar, is a creative act that falls within the ambit of copyright law. The question would be, well, whose copyright is it? Right? Is it the copyright of the creator of the avatar, or is the avatar body itself owned by the company that owns the platform? And of course, it doesn't stop there. This is Minecraft. This is a very popular virtual world nowadays that's started by an indie company in Sweden. But this shows you just how the entire world of Minecraft, the entire game of Minecraft, to some extent, is something like an artist colony, that you enter into the virtual world and you create structures. Just in order to participate, you need to be creative. And many people writing about virtual worlds have observed this, that really the value of a virtual world platform is created by the users, that essentially these platforms are about individuals forming communities where they entertain each other, and they entertain each other through creativity. So the conclusion of my chapter on virtual worlds and copyright was this, that virtual world users are in many ways like peasants laboring around the castle, adding value to the community, right? In many ways paying for the privilege to participate in that community. They pay subscribers' fees. They contribute their labor, to the territory, but the territory is governed by someone else. So essentially, participants in a copyright sense in virtual worlds are like serfs. So this is, I don't know if any of you have seen this picture before, but obviously what people do in virtual worlds is not limited to virtual worlds. The phenomenon of being creative, of kind of being communicative through creative acts, is not limited to virtual world platforms. It's just a manifestation of just common features of humanity. People just have a tendency to create and to share original things as ways of entertaining each other. This picture is just a day's output from Flickr. So an artist actually printed out all of the Flickr photographs that have been uploaded in one day, put them in a studio, and this is what it looks like when it's all, gathered. And obviously, it's somewhat staggering the amount of content that's being generated, the original photography being generated on Flickr. No one would have time to look at all of those photographs that were uploaded in a single day. But then think about adding on other forms of user-generated content on the internet: Twitter, blogs, software, YouTube videos, and original music, all of these things being made available online for free access, despite being subject to copyright restrictions, just being put out there. And of course, we can't forget Facebook, right? What is Facebook, in essence, but friends trying to entertain each other with new content, original stories, original photographs, acting as curators and editors of the internet, selecting the best things to share with other people. So Facebook is not a virtual world platform, but it's certainly a user-generated content platform. So this is obviously a vast oversimplification, but I think it's just useful to recall that the general premise of copyright law is that there are professional creators who need to be reimbursed for their creation, who are funded in that process by professional intermediaries, distributors, who then package the work and pass it on to the ultimate consumers, who pay for the work, pass the payment on to the distributors, who pass the payment on to the original creators. And this is the constant story of copyright law, that copyright is an engine for creativity that works on this property-based economic scheme, right? So obviously, extremely simplified, but I think that's the essence of what copyright is about. And again, this is also extremely simplified, but the thought is that with user-generated content emerging as a way in which creative material is generated, that we would have to see, all things remaining equal, a shift in the information landscape where professional creation of content would shrink somewhat because consumer demand would be reduced, because consumers would be willing to produce content that they themselves would consume, right? So the creativity from the users would flow back to the users by using the tools of the intermediaries to generate that content. Inevitably, that would mean a reduction in professional content, of course, unless we're just saturating ourselves with more and more content and adding the UGC consumption on top of the regular professional content consumption. So, summing this up, very quickly, right? The thought here would be that in a new UGC landscape, platforms would compete to entice popular creativity. I'll create a platform where users can entertain themselves, and I will provide tools, and that will be how I compete in the marketplace, providing better tools than anyone else, and better mechanisms for the distribution of user-generated content. Users won't be paid to produce the content. They will do so for free. They will pay, in a certain sense, by viewing advertisements. That advertising will be the basis for the revenues of the platform owner, possibly subscriptions as well. And just to throw this in, because I know that Fred is up next, there's a way of thinking about this and thinking about Google and its role, in that Google makes the majority of its revenues off of search. And what is search but using the web as a vast user-generated content platform, offering the web to users and financing that system on advertisements that are related to the search function, right? So I think that it's slightly different, but you can see Google itself as a platform. Google doesn't own the web, but in a way, by becoming the central locus for search, right, it does monetize the web in essentially the same way I'm talking about with regard to platforms and user-generated content. Okay, so there are critics of what's going on. I just want to mention this briefly. So this is Jason Lanier, Andrew Keene, and Mark Halprin there, just the pictures, but there are many critics, of course, of user-generated content. And some of the criticisms. User-generated content is cheaper, coarser, kind of culturally impoverished. And what we really need are information gatekeepers for culture on the internet. And user-generated content systems do not provide this function, so that's one criticism. User-generated content only works in limited genres. You're never going to see a user-generated content opera being created, right, and staged, right? It's only going to be in certain formats. The digital photograph can be taken in a second, right, and posted online very easily. But more sophisticated collaborative forms of content requiring significant financial investments are not going to be created through this system. A large amount of it is poor quality. successful UGC creators are really aspiring to be professional creators. They want to be paid for their creativity, and they would readily jump from the ranks of UGC creators to paid creators if they could. Obviously, this is not making money. And I think this is actually an independent criticism in itself, right? That there's no money here. Why should we care about this? This is not good for the economy to have people doing this for free. They should be paid. You know, one kind of especially harsh criticism, user-generated content creators are relying on others to finance their creativity. In a way, they're parasitical. And also artistically parasitical in that they are often basing their creativity on other material that is out there. They're doing remix forms of creativity rather than truly original creativity. So these are all criticisms. And I just could sum it up with this lolcats, right? Lolcats is kind of the target for the critics. This is the essence of culture in the future, people making lolcats. There are boosters, of course. So Henry Jenkins, Yochai Benkler, Clay Shirky, this list could go on as well. And I think rather than being fractured, their arguments are kind of more coherent in that user-generated content is more democratic. It's more representative of society, gives people voice. They can speak back to the media, make their concerns known through user-generated content. User-generated content is more collaborative, kind of echoing the previous 2 points, and it's more culturally diverse. So I think all of these kind of arguments cohere together, and there are additional arguments that they make, but their poster child is often Wikipedia, that this great online resource is being created through user-generated content without any kind of financial backing. So I actually don't want to argue in favor of user-generated content or against user-generated content. I want to be agnostic about the normative valence of user-generated content. All I want to say, though, is that it is extremely important culturally. So I think both the critics and the boosters are right just to focus on this topic. The interesting thing, of course, is that economically, if we talk about the value of the individual pieces of user-generated content, it seems very unimportant. The average Flickr photo, the average YouTube video, blog post, building in Minecraft is not making money. And copyright lawyers are not going to get rich by representing user-generated content creators. They may not be able to fund a copyright infringement lawsuit. But when we aggregate all of this, of course, it becomes very important. And arguably, user-generated content is the genius of the internet and is responsible for many of the social benefits that we reap from the internet. So I think the law has a duty, even if the economic valence of individual pieces is not there, to focus on this in the aggregate, trying to channel the law to maximize the benefits that we can achieve through user-generated content creation. So, other direction. So what's sort of curious, I think, is that by focusing on the professional side of the question of user-generated content, what we focus on is the intersection, really, of the aggregators and the professional content industries. Because it is at that intersection, this intersection right here, right, that copyright law evolves. This is where litigation happens. This is where the money is. This is where legislation occurs. And that's, of course, extremely important. And I don't want to diminish the battle between Viacom and YouTube or any of the other battles between the content industry and the tech industry. They are very important. What I would like, and obviously, we're going to be talking about this a lot, I think, over the next 2 days. It is interesting, but what I'd like to do is focus on this intersection, the copyright relationship between the user-generated content creators, the mass producers, and the intermediaries. And obviously, this content being created is protected by copyright, but it's interesting that when we talk about this, it seems as if our talks become largely theoretical. at this point, because we don't have the focus on this, we don't have the litigation, we don't have the lawmaking around this area. Which makes me think, well, what is copyright about? Why are we doing this? What's the basis of this? And this is going back to the Statute of Anne, so apologies for my bias towards the UK copyright law. The US copyright statute is cribbed from the Statute of Anne, of course, so this seems more familiar to me in many ways. And again, this is a simplification, right? But what we had pre-Statute of Anne, right, is a system where there were authors, and there were booksellers, and there were book purchasers. Right? We did have a system where content was being produced before we had the system of copyright. The problem, of course, was that the booksellers had this monopoly on the production of books. The London booksellers acted essentially as a cartel. And the problem in that system was the anti-competitive nature of that monopoly, that the booksellers were depriving booksellers elsewhere of being able to produce texts from authors, and this monopoly was seen as socially harmful and anti-competitive. So the genius of the Statute of Anne was this collaboration, in a way, between the booksellers and the authors, where the booksellers were able to continue exercising monopolistic privileges over the printing of particular books, but the way that they did this was to pass the copyright interest back to the authors. The authors exerted proprietary control over the copyright initially, could transfer that to the booksellers, and the booksellers could then, again, re-enjoy their monopoly. But the thought of this, and the reason that I think the authors found this a good idea, and why Parliament found it to be a good idea, there's many conflicting accounts of what happened here historically, was that by doing this, we introduced competition in booksellers, among booksellers. The competition is going to increase the payments to authors, because then they have to compete among booksellers. There's not cartel control. The competition for payment will lead to increased funding to authors, which will lead to increased production, delivering more books to booksellers. More books will come to book purchasers, which will send more revenues back. It'll be a virtuous cycle, and essentially we end up with a economically superior outcome in terms of an efficient production of information goods. So how does this work with user-generated content? Well, we get rid of the paid authors, right? And so therefore the paid product is going to disappear as well, right? And in its place we get this situation where users are producing for free and consuming what they produce for free, right? And what's odd about it is that we see this tremendous outpouring of production, all of those Flickr photographs, in the room. All of this stuff is occurring. So how does this make sense under the logic of copyright law? It seems to turn it on its head in many ways. And perhaps this is the reason why, when we talk about copyright and user-generated content, it seems as if we there's a barrier there to really grappling with this. Well, there's some possible arguments. One argument is that the economic rationale, just the economic rationale of copyright with regard to certain artistic forms, digital snapshots, right, is wrong. In that the economic rationale is probably specific to particular artistic forms, particular genres of artistic productions, because certain forms of artistic creativity today are actually superabundant, right? And optimally, they would be priced at zero. So we don't really need the copyright incentive for those forms of creativity. Now, probably, on the far end of the booster spectrum for user-generated content, that would be an argument for reform of copyright law. But that isn't what I really want to argue about. Actually, my concern is somewhat of the converse. What I want to talk about next is 4 cases involving that particular intersection between user-generated content and copyright law. These are 4 US cases where I think you'll be able to see the nature of my concern. 2 of the cases involve virtual worlds. to involve other platforms. They're all rather strange cases in that in 3 out of the 4 cases, the companies fighting over user-generated content are not generators of user-generated content. They are the platforms. They're a fight between platforms. But essential to the war between these 2 platforms is the copyright interest of the users who are creating the content. So that might seem strange. Why aren't the principals here? Why aren't the creators at the table? And once again, it's because of the small stakes involved that these user-generated content creators will rarely lawyer up. But I think these cases shed some light on how user-generated content and copyright is interacting today. So in Chapter 9 of my book, I talk about this case. It's becoming an old case now. Marvel versus NCSoft, which is the virtual world of City of Heroes, a virtual world where people put on superhero costumes and move around. As you can see in this picture, all of these costumes are created by the individuals, and the customization, the building of your costume played a large role in this game, which is still out there. In fact, some people play this game just in order to create superhero costumes. And then they go to this place, this central kind of square, and they have contests where they compete for who's wearing the best costume. The problem was that these are superhero costumes, and there's a IP rights holder, Marvel, who has a vested interest in the copyright in superhero costumes. And in monetizing the superhero costume space. So Marvel sued the game creator, NCSoft, and it sued NCSoft for providing the tools that enabled people to create these superhero costumes. The case survived a motion to dismiss, but was later settled. And actually, I quote Fred at the beginning of the chapter on this, because Fred wrote an interesting little piece about what a ridiculous case this was. It's terrible. You'll be suing crayon producers for selling crayons that enable children to draw Superman or something like this. So, interestingly, of course, the claim was based on copyright infringement. And the claim was that by providing an engine for the creation of superhero costumes, NCSoft had enabled the individual creators, individual user-generated content creators, to commit copyright infringement. And the thought was that particular elements of the content creation engines, for instance, giving an avatar clause, was a way of enabling people to violate the copyright in Wolverine, which is a Marvel character, and therefore there should be no claw feature in an avatar creation engine for this game. And the interesting thing, of course, is that Marvel makes this claim. NCSoft says it must be dismissed. It's ridiculous. We can't be sued for just giving people essentially a digital box of crayons. And the court actually said, no, there's a valid complaint here. We're going to actually let this go on to the next stage. So it survived the motion to dismiss before being settled. Which, of course, is troubling in that if what we're trying to do is optimize the value of user-generated content, the worst thing that could happen would be to enable copyright itself to destroy the tools that are being used to enable this form of creativity. So here's another case, the MDY case, which someone will be talking about later in this conference. The MDY case was also involving a virtual world, this time World of Warcraft. And we had, again, a kind of proxy battle over user-generated content. MDY was a company that made a piece of software called Glider that enabled avatars in the context of World of Warcraft to perform actions without a user being at the keyboard. So you could essentially set your avatar on autopilot to be able to run around in Azeroth, the world of World of Warcraft, and do things that would be beneficial to your character. So this was a piece of software written to interface with World of Warcraft and to enable individuals to do this. A creative piece of software. It sold many copies. Many people wanted to have this kind of functionality for their avatars. The game owner, Blizzard, did not want this kind of functionality for avatars. It also did not like MDY, this company, making millions of dollars by selling this piece of software to consumers, a piece of software that essentially interfaced with its platform and monetized user activity on its platform. So MDY sued, Blizzard, well, actually MDY sued for declaratory judgment, but Blizzard was really bringing the claims against MDY, and the claims included contributory copyright infringement and a violation of the Digital Millennium Copyright Act, the anti-circumvention provisions of the Digital Millennium Copyright Act. There was also an interference with contract claim there as well. And the thought was that by selling a piece of software to users, the use of which violated the licensing terms of the World of Warcraft software, and enabling users to violate the terms of service and use this avatar automation program while interacting with World of Warcraft, that MDY was contributorily liable for the infringements of users, right? So the thought was, when you're on the World of Warcraft platform, you must abide by certain rules. If you do not abide by those rules, you are committing copyright infringement. Why? Because in order to play World of Warcraft, you need a license to make a copy of the software onto your personal computer in memory. If you do not abide by the license when you use the software, you are guilty of copyright infringement, right? So the users are being charged with infringement, and MDY is being charged with contributing to that infringement. Now, ultimately, the Ninth Circuit rejected that claim. The federal appellate court rejected that claim. But I don't think there's obviously no Supreme Court determination on this, and the way that it rejected the claim was very unusual. The other claim was also very interesting, the other copyright claim. Blizzard claimed that by circumventing its access protections, that this software, Blizzard had a program called Warden that detected whether you were using unauthorized add-ons to your software, unauthorized botting programs. The Glider software attempted to evade detection by Blizzard's Warden software, and Blizzard claimed that by evading detection from the Warden software, MDY had circumvented its access protections and engaged in a violation of the Digital Millennium Copyright Act. So the determination with regard to that was, indeed, that had occurred. The interesting question was, well, it had to circumvent in order to get access to the Blizzard servers, but actually all of the standard copyrighted content was actually present on the user computer, so there was no circumvention required to get to the individual images, animations, and sounds that existed on the user computers. So how was this circumventing to get access to copyrighted content? The court said that the servers themselves, this virtual world, was not the individual elements, but it was the interplay of those elements kind of working together to form a kind of total gestalt copyrighted work. And obviously that copyrighted work, that total gestalt copyrighted work for most players was interactions with the other players. But the court concluded that Blizzard, the game company, owned the work that was created by user interactions on its platforms. And those user interactions were essentially a copyrighted work that it had created. So it choreographed user interactions, and by enabling users to get to that community, the MDY software had violated the Digital Millennium Copyright Act. So again, a very strange case, but if you're a user, you're interested in creative ways of avatar automation, if you feel you have maybe some interest in getting to a community where you participated as a creator, a co-creator of that community, this is a troubling decision, I think. Okay, so moving away from virtual worlds, this is another case, a recent case, which is again unusual. An anti-plagiarism company, Turnitin, in the United States, collects papers of students in college and in high school and indexes those papers in order to help teachers determine whether or not a student was just copying their book report from the internet. So it has a vast database of student papers. Students turn in papers. The teacher takes the electronic document, scans it through Turnitin, and says, oh, this was written before. You just copied it off of the internet. And then there's a discussion between the teacher and the student. The interesting thing is that in certain schools, high schools in the United States, you must use Turnitin. You have no choice. Right? So the school tells you, you've written that report, that original report, that original copyright-protected creativity that you engaged in to write your student book report. Now we're going to upload that onto Turnitin servers, and if you don't agree to that, you're going to fail this course. Right? So you're required to submit your paper to Turnitin. So some enterprising creative students say, well, I'm going to write a disclaimer on the top of this paper saying, you have no right to archive my paper. I deny you a copyright license to my paper. And they submit the paper with that disclaimer attached. And the company, of course, goes ahead and archives it, puts it into their database. So the students sue. This is the one case where the students, the user-generated content creators, are actually suing the platform. And the students say, you violated our copyright. The Fourth Circuit Court of Appeals says, no, there is no copyright infringement. Why? Fair use. And I'm usually a great fan of fair use. I love fair use, right? But it seems to me that this is the paradigmatic case where, fair use is really not very fair to the creators. The court says, stepping through the factors of fair use, it says that this is transformative. They're not trying to get the economic value of the paper. They're just trying to use it for a different purpose, a laudable purpose. So it comes up with an analysis that finds that this is fair use of the papers. And even worse, the paper company, the Turnitin company, sues the students because it says that one of you students actually submitted this paper using an account of your friends, and when you submitted that paper using the wrong account, this was a violation of the Computer Fraud and Abuse Act, so the hacking laws, right? And it says you're guilty for hacking into our system. And by the way, we're using your paper. And the appellate court says, you know what? There's a cognizable claim there, right? It says, it actually, on appeal, it says that the company wins, and the students, get their hands slapped. They lose their claim, they get their hands slapped. You're at risk of committing a felony by circumventing the access restrictions in order to get into our servers. So troubling, I think, if you think about where the value is and how copyright law is being used in this case. And the final case involving Facebook versus Power Ventures, a recent case. So there's a company that is trying to be an aggregator of social networking data and kind of trying to interlace Facebook and other forms of social software across the internet. It's Power Ventures. It's now defunct, but it was at one time a working company. So essentially you log into Facebook and Power Ventures would request that it be granted permission to provide access, to gain access to your account in order to get information about your social network. I don't know if Power.com was a particularly upstanding actor in all of this, but the war between Facebook and Power.com, I think, is very revealing about the copyright questions. Power.com was trying to scrape data from Facebook. It was trying to get access, to Facebook in order to scrape the data that users had uploaded to the website, including some of the basic data on the website. And Facebook did not want them to do this. Of course, Facebook wants to have complete control over its social software platform. So what did Facebook sue for originally? Copyright infringement. You're taking the data on our site and you are scraping it. You are making copies of the Facebook platform, So you're in violation of copyright law. Additionally, as we go on, claims get added. The Computer Fraud and Abuse Act. You are circumventing the access controls to get through to our platform, and the California Computer Fraud and Abuse Act. Additionally, the Canned Spam Act as well. The final outcome of the case, as the Power.com really stopped defending the case, I think, very ardently at a certain point. But the copyright claims were allowed to go on. I think Facebook dropped them eventually, but they survived a motion to dismiss. And it was interesting in that the court recognized that if you upload photos to Facebook, Facebook should not have standing to sue for copyright infringements of those photos, especially if, a company that you've authorized to make use of this data, Power.com. However, it said that when you upload your photos and other stories to Facebook, the basic interface of Facebook, like the web page, has elements that Facebook has designed, and Facebook's copyright in those particular elements granted it sufficient standing to bring a copyright claim for scraping of the data from the website. Additionally, the Computer Fraud and Abuse Act claim is upheld against Power.com, and in some ways, there were some good things about the decision in that the court said that just because the terms of service prohibited a certain use, that did not turn this into a Computer Fraud and Abuse Act claim. But it did say that because Facebook had used its technological powers to block Power.com, and Power.com was aware that Facebook was using its code-based powers to try to stop it from getting through to its site, that was sufficient to create a Computer Fraud and Abuse Act violation. The interesting thing about this case for user-generated content, of course, is that users aren't present in this dispute at all. But really, this is a war over the portability of their information. And a company that they have authorized to access their data is seen as being a violation of the as violating the Computer Fraud and Abuse Act by trying to exercise the license of the users. The users don't have authority to license Power.com to interact with Facebook in a way that Facebook does not permit. Okay, so what I am concerned about here is that the platforms, with regard to user-generated content, are essentially doing what I was talking about with virtual worlds generally. That increasingly we're moving into a space where user creators, who would think of as authors, are really providing copyright labor and value to platforms, and the platforms are monetizing that value in a way that deprives the users of any really significant control over the works that they create. That these are essentially walled gardens, privately enclosed walled gardens. You go in, you create, but you don't really own the garden, and you can be kicked out at any time, right? And your work stays inside that sphere. So my conclusions is that these platforms are becoming privately owned spaces. The ownership of the chattel, the basic server mechanism, provides ownership, legal ownership of the content onside it. If the content is not portable, and if the primary economic returns of user-generated content are obtained by the platform owner and not the author, this is a problem because we're moving away from copyright as a mechanism of protecting authorship towards copyright as a mechanism for protecting platforms as a form of property. And that's why I titled the talk Stationer's Company 2.0, right? We're moving into a sphere where instead of copyright law incentivizing authorships, we're using copyright law to provide a kind of anti-competitive status to platform owners. So my recommendations, and I've been making these recommendations for a while, so I'm not really sure they're going to be observed. But my first recommendation is don't kill the tools. So the City of Heroes case, the Marvel versus NC Cough case, is the paradigm of this. that if you really want to value user-generated content, the MDY case is an example as well, don't kill the mechanisms by which user-generated content value is created, right? Do not prohibit users from generating, new value. And of course, affording greater latitude for remix, and this goes back to the classic concerns about the war between tech and copyright. Users are going to repurpose existing content, derivative works, protections for remix content, I think, need to be included in copyright law. But more importantly, I think, protecting creator interests. That if there are markets, and there is profit being made off of user-generated content, create a mechanism to share that profit with the user. And in the case of, to hold out an olive branch to Fred, YouTube offers ways in which YouTube videos can be monetized by their creators and offers a way to share the value with creators. Even Google's AdSense is a way of allowing web creators to share it to a certain extent Google's advertising revenues. So there are ways to do this. I just wish they were more common. Allowing access rights to user creators, creating more data portability, fairness in terms of service, rather than just accepting the terms of service as a whole, some kind of serious judicial scrutiny of the fairness of particular terms with respect to copyright, I think, is required in our new world. And moral rights approaches, I think, towards copyright. Non-economic rights of authors need to be seriously considered, especially in the United States and countries which do not recognize moral rights. I think the United States is the main culprit in this regard, but I think there need to be expanded moral rights protections given user-generated content. And that is it. Thank you very much.
Thank you, Professor Lastowka, for your interesting speech. Now we have time for 2 short questions, or now we have time for 2 short questions, and after the Professor von Loopman presentation, we will have more time for the debate. Professor Marsden, please. No, because the translation, you need the microphone. Okay.
Thank you. Chris Marsden, University of Essex. Greg, that was fascinating. And I take your point about one of the problems for Anglo-Americans is that we come into a venue and we say Statute of Anne and have an economic model that we adopt. And so, of course, this is a problem that we have.
Right.
But I'm just wondering to what extent you think that the fact that a lot of this is personal data belonging to the users might make a richer and more complex kind of balancing of rights from the point of view of courts. I appreciate in the United States this is a less powerful tool than in Europe, but I don't know if you'd like to kind of speculate a little about that.
No, it's true, and it's interesting. Julie Cohen's got a book recently, Configuring the Network Self, that's just come out, and I've only started working through it. But her main claim in that book is that we need to see the privacy interests and the copyright interests as of a piece, two sides of the same coin. I think the privacy interest historically has been perhaps unfortunately seen as a secrecy interest. And there's the tension with copyright, because user-generated content is being produced so that others can consume it, whereas personal data is often seen as when we protect the user's rights in their data, we're doing a good thing for the user, at least not a bad thing by keeping that from getting out there. So I think there's a certain tension in there, but I do think it could be productive, and maybe Julie has the answer to this question that you've asked. But obviously, yeah, they do intersect, especially when we're talking about, when I'm talking about user-generated content in Facebook stories, for instance. Those could be protected under a privacy regime as well as a copyright regime. Perhaps even the privacy regime is more appropriate to the nature of the content that's being generated. So I take your point, and I think privacy as property is an interesting path to pursue. I don't have answers, but I think it's productive.
Is there any other question? Then.
Okay.